can't remember what it was. I'm not representing that that's what it was, but that's the basic essence, and I believe it relates back to due process, fundamental right to a fair trial.
Yes. So it is 117 Supreme Court Reporters 644.
And so we can stipulate that the officer can come in and testify and look at the photographs that are taken of it at the time, and you can say, that trigger, how does that gun have to work? We won't object later. We won't argue that they didn't sufficiently prove how the gun works and what makes it so dangerous. But bringing a firearm into the courtroom now with the additional delay that's going to be required for not following proper protocol and bringing a weapon into the courtroom, it's just not need to go there.
So it will not cause any delay, Your Honor. And I followed the protocol. I just emailed the sergeant of the courthouse to let him know, and I also talked to the officer via email saying, please bring a trigger lock. So there'll be no delay. And that stipulation is not sufficient for the state. So it's just, the state is not willing to agree to that stipulation.
Does anyone have any other cases they want me to consider? Because I'm going to rule and then I'm not going to hear more arguments.
If I can have one moment, I'm reviewing Rich v. Cooper, a case that you're currently relying on. I just want to see if I disagree with your reading of it. Yeah.
Okay. So here's the question. This is a case that I don't know if you want to look to see.
I mean, I will just say additionally that I don't think the state has articulated why the operation of the how the gun works is important. With regard to the gun, he is not charged with attempting to use it at all. If we were into an argument of whether he took a substantial step, then maybe.
Isn't UUW with a firearm carrying with intent to use,
This,
attempting to
I mean, this is why I want elections, because the state has just muddied the water by saying that, you know, basically for all eternity, Alan is intending to. That's hyperbole, thank you, but it's true. He says that he was using. I mean, he was. Let's go ahead. If he, you know, if we can prove that he was in Clackamas County that morning, let's go ahead and charge him in Clackamas County for the same thing, right?
you have gone completely into hyperbole. At this point, that's not the state's theory of the case at all. And as I understand it, and again, I'm not trying to make the state's argument for them, but as I understand what Mr. Vasquez is saying is the manner in which Mr. Swinney is photographed with his hand pulling the trigger back or pulling the hammer back and his finger on the trigger are relevant because of the way this particular gun is operated, and that can be discussed and demonstrated by the officer. Now, I understand you're saying he can look at a picture and he can say it. I disagree with you. I think during voir dire, you both talked to the jurors about firearms, or both parties addressed firearms with the jurors. You know, the jurors who said they had strong feelings about the firearms are not on this jury anymore. And in fact, jurors that were quite comfortable with firearms remain on this jury. So I am not concerned that seeing for demonstrative purposes a firearm is going to so inflame the passions of this jury that it will unduly prejudice Mr. Swinney. I think this is a demonstration like any other. And so based on the existing case law, based on the fact that the state is unwilling to accept a stipulation, and I agree that the stipulation does not get the parties to where they need to be, which is a distinguishing fact from Old Chief, that the witness and evidence is allowed in.
I'll ask Your Honor to make a 403 balancing analysis on the relevance issue. I do believe it is unduly prejudicial. I believe it'll invoke the emotionality of the jury.
When I said I did not think that the jury's passions would be inflamed, that was, I guess, me not saying specifically enough that I don't believe there is a danger of unfair prejudice. I don't believe that this is prejudicial at all. I believe it is demonstrative. Anything else we need to do before we get the jury in here? Okay.
I believe we're ready, Your Honor.
Does anyone need to use the restroom before we get the jury in here?
Okay.
Your Honor, I wanted to address, since Officer Ashon's testimony is coming in regarding the gun, we're asking that he not be allowed to be shown the video and narrate what he sees on the video. He's going to demonstrate how the gun works. The jury can take a look at the video and see if they see it.
It's evidence that has been admitted in the trial. I don't know why a witness couldn't testify about evidence that's already been admitted into the trial.
I am not hearing a legal basis for it keeping the officer from testifying that how Mr. Swinney is holding and handling the firearm. I mean, that's the entire point. So your motion's denied.
It's commenting on the evidence. The video.
That's what witnesses do. Your motion's denied. Let's get the jury in.
You're not gonna have anybody besides Officer Ashheim hold the firearm, correct?
No, I mean, witness-wise, no.
You're not gonna be asking the client to hold the firearm. I'll do that.
Good morning, members of the jury. Thanks for coming back this morning, and the state is going to continue with its presentation of evidence.
Thank you, Judge. Call Megan Stewart.
If you'd remain standing for a moment and raise your right hand, please. Under the penalty of perjury, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Can I have a seat up there? And if you please state and spell your name.
Megan Stewart, MEGANSTEWARD.
Good morning, Ms. Stewart.
Morning.
First up, can you tell us, do you live here in Portland?
I do.
And how long have you lived in Portland?
Since about March of last year.
And where had you lived before that?
Well, I was originally born here. I move around a lot, but before March, I was living in England.
And about how long had you been living in England?
About 3 years.
Okay. Are you working right now?
No.
What had you done before you were unemployed?
I'm a freelance graphic designer, but I suffered an eye injury this year, so I'm on hiatus till that gets fixed.
Okay. I want to talk to you about an event on August 22nd of last year. Do you recall that date?
Yes.
And were you in the downtown Portland area on that day?
I was.
Okay, can you tell me what caused you to go to downtown Portland that day?
I saw, I think it was on Facebook, an ad for what looked like a political campaign rally for the Republican candidate for president. And it was an election year. I thought it important that I know the candidate.
Okay. And do you know where it had said the event would be?
It was going to be downtown near the Justice Center.
Okay, were you familiar with that area before?
Yes.
From growing up here?
Yeah.
I take it. Okay.
Here, I apologize. Is it okay if we have the witness, if it's okay with Ms. Stewart, remove her mask? I just want to make sure we can hear.
I can scoot closer. I'd like to keep it on if possible.
Okay.
If she wants to keep it on, she can keep it on.
Certainly, thank you.
Of course.
And did you eventually go down to the event at the Justice Center?
I did.
Did you go with anybody else?
No.
What did you see when you first got down there?
I arrived, I had just crossed the bridge and I got to about 3rd and saw a group of people in the street standing in front of the building. Lots of flags, and there were some children in the crowd. Lots of people wearing like fatigues or pro-Trump shirts and stuff like that.
How did it sound when you first got there?
Just like a normal cheering crowd.
Was there any, I guess, sort of division between groups as far as you could tell when you got there?
I didn't realize that there was 2 separate groups there. I saw some people kind of milling about in the park that the group in the street was facing, and I was still being careful about COVID due to my father being ill. So I decided to go into the park where there was less people.
Okay. And what did you do when you got into the park?
I just started walking down looking for anybody that might be handing out information about the presidential candidate or speaking about him or anything like that, just sort of surveying the area.
Okay. And did you take any particular route as you went through the park?
I just went straight along, just maybe 6 feet off of the sidewalk in the park, right down the street.
And when you say 6 feet off the sidewalk, is that on the, and we're talking about, is it Chapman Square in front of the Justice Center?
Yes.
Okay. And so when you say about 6 feet from the sidewalk, is that 6 feet from the sidewalk on 3rd or on 4th Avenue?
I don't know exactly. It was 3rd, where the group holding all the flags and everything was.
On the Justice Side Center?
Yeah,
over
I
there?
was just little ways off the sidewalk, which had a lot of people. I was just trying to avoid crowds.
Okay. And so you said you were walking across the park?
Yes.
Okay. What happened as you were walking across the park?
When I got, there was a large van that had BLM painted on it at the middle of the street parked. When I just passed that, I saw a line of men holding shields, like homemade wooden shields, and wearing protective gear. It was a very odd sight. I had never seen anything like that, so I got out my camera to record it.
And the men that were holding the shields that you thought was odd, were they facing towards you or in the same direction as you?
They were facing towards the park.
Okay.
Yeah,
So,
they were maybe 6 to 10 feet in the street.
okay, and so you saw these people with shields, you thought that was odd, and you said you began to film that?
Yeah.
And was that with a camera or a phone or something
I had
else?
my phone with me.
And what happened as you began to film the scene?
I hit record and I started walking down, and pretty much the moment I hit record, I looked up and there was a man standing straight behind the men holding shields, about a foot taller than everybody else, and he pointed a weapon straight at me and then fired.
At that point, could you tell what the weapon was?
No.
And when he fired, did you feel anything?
It hit me in the chest and just kind of knocked the wind out of me and stung really bad.
At that point, could you tell what it was?
I looked down and saw paint, and I assumed it was a paintball.
And you said you took a video recording of this?
Yes.
Okay. If we could actually bring up, I had photos primed, if we can bring up video 70, it should be, exhibit 70. So I want to show you what's been marked for identification as State's Exhibit 70 and see if you recognize this.
Just got hit in the tip with the fucking paintball.
Okay, so you've now had a chance to see some of that. Do you recognize this video?
Yes.
Is this the video that you took on that day?
Yes.
Okay. I'd offer this as State's Exhibit 70, Your Honor.
No objection, Your Honor. Received.
All right, so I think we started kind of in the middle there when it was actually viewable, so I'd like to watch that again.
Just got hit in the tip with the fucking paintball.
All right, and is that where you stopped the recording?
Yes.
And in that video, are we seeing the men with shields that you described earlier?
I was pointing it at them, but when I looked up and saw the man pointing a weapon at me, I wasn't sure where my camera was pointing. But yeah, that was the men with shields that I was trying to film.
And you said the man with the weapon pointed at you was about a foot taller than everybody else in that group?
Yes, he was standing behind men with shields.
Was there anything else that was distinctive about him?
He was just very tall, had a beard. He was wearing what looked like riot gear. That's really all I could tell.
And could you see that at the point, around the point where he shot you?
Yes.
How did you, well, let me ask you about the, you said you eventually assumed that it was a paintball that struck you.
Well, I looked straight down and saw paint.
Okay. And how did that feel when it hit you?
It was extraordinarily painful and just sort of knocked the wind out of me.
Have you ever had experience with paintball guns?
Yes.
So had you been shot with a paintball before?
Yes.
How did this time compare to previous experiences?
I've always worn padding when I play paintball, so this was definitely more painful, and the fact that it was just unexpected and really took me off guard.
Did, later on in the day or sometime later, did you have a chance to check on your body where the paintball struck you?
Yes,
Did you have any signs of injury?
I had a fairly large welt on my right breast.
And did it continue to feel painful after the initial strike?
Yeah, I could not put on a bra for about a week.
Did you have any other experience of pain or discomfort?
From the pepper spray later on,
But from where the
that,
paintball struck you?
it was mainly just sore. If I rolled on it at night when I was asleep, I'd wake up.
So you said it was painful enough that you either had a difficult time or couldn't put on a bra for a week, is that what you said?
Yes,
How long did it otherwise hurt or affect you?
it was just about a week.
About a week.
Yeah.
And how long did you have a welt or a bruise or a mark of some kind?
The bruise went away after about 2 weeks.
Did you document the signs of that injury?
I took photos when I got home later.
Okay, and did you eventually provide those to a police officer?
Yes, Officer Peter Braun, I believe.
Okay, I'd like to bring up, if we could, what have been marked for identification purposes as exhibits 38, 39, and 40. Can you see on the screen there what's been marked as State's Exhibit 38?
Yes.
Do you recognize this photo?
Yeah.
Is this one of the photographs that you took?
I took that later in the day, yeah,
Okay.
after my eyes had been washed out.
I'm going to pause on this one and go on to number 39, if we could. Do you recognize this photograph?
Yeah,
And what is this a photograph of?
that's the area where I was shot on my jacket.
And did you take this photo?
Yes.
And I think we can kind of see it's, I guess, is it your right arm? Are you taking kind of a selfie?
Yeah.
When did you take this photo?
I took that around 7 p.m. When I got home that night.
Okay, so same day as
Yes.
this event. Is that what you were wearing today, or that day?
Yeah.
And I guess we're seeing kind of I'm not sure if it's a yellowish or greenish, is that the paint from the paintball?
Yeah, and there's also white stains from the chemicals that they were putting in my eyes.
Okay, so your jacket didn't look like that before this event.
No.
And Judge, at this time, I would offer this as State's Exhibit 39.
No objection.
I want to have you take a look.
Do you want to offer 38?
Not yet. I want to have her go back and talk about that in a minute.
39 is received.
If you can take a look at now what I'd like to bring up State's 40. Do you recognize this photograph?
Yeah.
And what's this a photograph?
This is where I was shot on my right breast.
Okay,
It's the welt that developed.
Okay. Did it look like that the entire time?
It turned black eventually. I didn't get any pictures of that. I felt that this was enough to show that there was an injury.
And how long after you got shot was this photo taken?
That was around 7 p.m. as well.
And this is one that you took as well?
Yes.
Okay. I'd offer this as State's Exhibit 40.
No objection.
Received.
All right. Did you at some point after being shot with the paintball make any effort to further identify the person who had shot you?
Yeah, I first saw that my camera, the video record option doesn't have a very good camera, so I switched it over to photo and tried for a few minutes to avoid the area while getting a photo of the man who had shot me. I wasn't able to in the end because there was just never a clear view that was close enough.
Okay, can you tell us in a little more detail where you went and how you tried to find the man who shot you or photograph him?
Yeah, so there was a van parked slightly behind the other large van, and the shield wall had been between the two, essentially. So I was just hiding behind the vans, and when people looked distracted, I would try and pop out and get a photo if I could, but there was never a clear view. And then at some point within those few minutes, somebody from what seemed like this, at that point I had kind of recognized that there was battling sides. Somebody from I'll call it the left side, was hitting either a pipe or a metal bat on the ground in front of the shields, and somebody in the shield group either swung at him or pushed him, and then a big fight broke out. I took that time.
Your Honor, relevance. Overruled. You may continue.
I took that moment to try and step out and get a photo, but there was just too much chaos to get anything. And then somebody sprayed a large amount of bear mace, which created just a cloud. And it didn't get me directly, but it was enough that it did irritate me, and I ran off.
Were you able to see who deployed or sprayed that bear mace?
I didn't recognize them at first, but the last thing I saw was them throwing the can at the crowd, and they posted a video of themselves doing that later.
Okay. To be more direct, was it the same person? Did it look like the same person that you'd seen shoot you with the paintball gun?
No.
Okay, so a different person.
Yeah.
Did you get another? I think you said you did not get a photograph of the person that shot you with the paintball gun.
Yes.
Is that right? Did you get a better look at that person at some point?
Yes.
Okay, and how did you do that?
It was just while I was trying to get the photo, I was, weaving in and out of people, ducking behind things, and I did get a clear view with my eyes, just not my camera.
Did you, on that second viewing, when you got a little closer, did you notice anything additional that was distinctive about him?
Same stuff, just I saw that there was a Texas patch on his chest. I couldn't read that from the distance I was before, but it was just, I only saw him from the waist up, essentially, and it was the same thing.
And do you see that man in the courtroom today?
Yes.
Okay, can you indicate, for the jury's sake, who that person is?
He's sitting at the defendant's bench.
Thank you. Between the two lawyers?
Yes.
If the record will reflect that the witness has identified the defendant.
It will.
Did you report this incident to police?
I did.
And I think you'd said previously you provided some photographs to, was it Officer Braun?
Yes.
How did you, I guess, was the police response, did the police response to your report feel immediate?
I did get a call from a different officer that night. They seemed very overwhelmed with some events that were going on, and he just seemed a bit overruled. He just seemed a bit distracted and came off a bit rude. So I called back and just asked for another officer to contact me when they were more available.
And at some point, did you file a civil lawsuit?
I did.
And why did you do that?
It had been quite some time since I had first reported everything, maybe a couple weeks, and I had seen events get more and more dangerous online.
And relevance.
Um,
404.
I'm happy to leave it there. There's not going to be.
yeah, let's move on.
Okay. And were there any other incidents on this day where you were struck by mace or paintballs or anything else?
Yeah.
Okay. Can you tell me about that?
So after that first interaction, I went to the opposite side of the park and crossed the street. I was a bit afraid that since I had been shot by a paintball, I was marked, and I didn't know if somebody would attack me if I was walking home on my own. So I just waited till I saw the group of people waving flags. I saw it essentially divide in two and go down two separate directions away. And I thought at that point the event was over. So I headed back towards home, and as I crossed through the park, there was a bin. I had picked up some rubbish while I was waiting, and I went to toss the rubbish in the bin and then bent down to adjust my shoe, and I heard some people to my left yelling. I looked over, there was maybe half a dozen people in full head to toe black, and then the same man who had shot me came out from behind a car and sprayed bear mace at them, and I looked over, and then he shifted his hand and sprayed it straight in my face.
Okay. How did that feel?
Extraordinarily burning.
How was your breathing at that point?
It was hard to breathe. It had kind of caked over my, I had a COVID mask on, obviously, and it caked into that, so I had to tear that off, but I couldn't see, and just kind of wandered into the street.
How long were you feeling any effects from that incident?
It was hours, and then I have very sensitive skin, so I ended up getting blisters on my nose and my cheeks, sort of like a bad sunburn.
Had you ever had an experience with mace or pepper spray or anything like that before?
No.
And you described, I think it is, did you describe it as bear mace?
Yes.
And what made you say that?
I live in the woods. We have bear mace. I know that it's an orange color when it comes out, and I had orange color all over my shirt and my face.
And the canister that it came from, was it sort of a small, like the kind that you can put on a keychain, or was it large?
No, it was a large canister.
Okay, could you tell us roughly how big?
Probably about the size of my water bottle, but a little bigger around.
So maybe if I were to estimate the size of your water bottle, maybe 10, 12 inches tall, something
Yeah.
like that. And I want to go back now to Exhibit 38, if we could. What's been marked as State's Exhibit 38. So you said you took this photograph as well?
Yes.
All right, and what do we see in this photograph?
This was after the first cloud of bear mace that it didn't get me directly, but had gotten me enough that it hurt really bad. So somebody washed out my eyes. After the second, when with the bear mace hit me directly in the eyes, I didn't take any photos because I couldn't see for quite some time.
Okay. I would offer this as State's Exhibit 38, Your Honor.
No objection, received.
And I think we've seen a little bit of what you were wearing that day. Is that right?
Yes.
What were you? So you had like is it a T-shirt?
Yeah, it's just a plain white T-shirt with a picture of strawberries.
And the green sort of cargo jacket?
Yeah.
What were you wearing on your legs and feet?
Leggings and a pair of boots.
Were you, so safe to say you weren't wearing all black?
No.
Did you have on a gas mask?
No.
Helmet?
No.
Did you have anything covering your eyes?
No.
Did you have any weapons?
No.
At the moment when you were shot with the paintball gun, or with the paintball, what were you doing? Were you doing anything besides holding up your camera, your phone, and filming?
No.
Were you throwing any objects?
No.
Were you pointing anything at the crowd?
The camera.
Were you doing anything that somebody could reasonably perceive as a threat?
No.
Rephrase the question.
Sure. Were you intending to threaten anybody with your phone?
No.
Could you see what anybody standing immediately next to you was doing?
I did see somebody holding an umbrella, like a shield towards the group in the street. And I did at one point see a water bottle get thrown into the crowd in the street, as well as things from the street being thrown back.
You say eventually. At the moment that you got shot, how far in time was the water ball being thrown?
That was just after.
Afterwards?
Yeah.
Okay, so you got shot and then a water bottle was thrown?
Yeah.
Just double check. Just to double check, we did Exhibit 70, is that correct?
Yes, it's received.
Questions? Thank you.
Examination.
Good morning, Ms. Stewart.
Morning.
My name is Megan Desai. I'm one of Mr. Swinney's attorneys. You and I have never met before.
No,
We've never talked before.
no.
Just have a few questions for you.
Sure.
Let's go to the moment that you arrived at Chapman Square.
Mhm.
You started walking through the square,
Yes.
and you noticed a group in the street,
Yes.
and you noticed another group kind of on the edge of Chapman's Square.
They gathered kind of, I arrived, it was still sparse and they gathered up as I was walking through.
You were approximately 20, 30 feet from 3rd Avenue.
In which direction? In the park?
Yes.
I was probably 10 to 15 feet from the street itself, yes.
And you had your phone out.
Yes.
And you took your phone out because you saw men with shields in the street.
Yes.
And you specifically took out your phone to film those men in the street with the shields.
Yes.
You also spoke to Officer Braun the day after this incident,
Yes.
on August 23rd, 2020.
Yes.
And you also testified at grand jury on September 8th.
I believe that was the date. Would have to check.
And at grand jury, you testified that you saw people screaming at each other in the road when you arrived at this rally.
I don't know if it was when I arrived. It was when I saw the men with shields. That's when I started hearing screaming as well. It was more the center of the street as opposed to the edges.
At grand jury, you testified that you took your phone out to record someone yelling something horribly racist.
I did. I didn't catch that on camera, obviously. It had already been said.
And so you had your phone out. Is that correct?
It was in my hand the whole time, yes.
And you were filming.
At the point when I hit record, yes.
The Exhibit 70, the video we
Yes.
saw, that was you filming.
Yes,
And it's a short video, about 9 seconds.
yeah.
And could we have Exhibit 70 up there,
Yes.
Mr. Schweitzer? Thank you.
Reload it. Can you play?
Yes.
Just got hit in the
Stop it. Thank you. So that person on the video that we can hear just a second ago, it just got hit.
That's me. I don't usually use that kind of language, and I apologize, but yes.
That's okay. That's okay. That's you on the
Yes.
recording, and that's the moment that you're hit with the paintball.
Yes.
And if we could continue playing it.
Hit with the fucking paintball.
And after you were hit, you continued filming for a few more seconds.
Yeah, I think when I bent down and said, the second time I hit the stop recording button again.
Could we start at 5 seconds on that video?
Sure.
Just got hit in the tit with the fucking paintball.
So it looks like you were hit, or you say you were hit at about 5 seconds. Is that correct? And then, actually, the clip is 11 seconds long.
Yes.
And so there's some additional filming after you're hit with after the paintball.
A few moments, yes.
And you said you've been paintballing before,
Yes.
and you generally wear padding when you go paintballing.
Yes.
And on that day, you weren't wearing any padding.
No.
So today you testified that after you were hit with the paintball, you eventually had some mace in your eyes.
Yes.
Not that someone sprayed you directly,
No. No.
but you're downwind.
It was just a very large cloud that was hard to avoid in the area.
And today you testified that that first mace in your eyes didn't hurt much.
It stung. It definitely stung, but it wasn't like getting sprayed directly in the face where it stuck to you.
at grand jury, let me take a step back. You testified last year at grand jury, is that
Yes.
correct? About September 2020.
I wouldn't remember the exact date, but I did testify at grand jury around September.
Okay. And that's closer in time to August 22nd, 2020.
Yes.
I'm going to show you the grand jury transcript from September 8th, 2020.
Sure, do you have a portion?
I was going to show the first page, and then starting with the first time that you got bear mace in your eyes, you went to the other side of the park to wash it out.
Yes.
Let's go to just kind of your, since you've been back from England. So you were there to observe a political rally that
Yes.
you had seen an ad for on Facebook. Is that correct?
Yeah. I lived for 2 separate presidential campaigns in New Hampshire, and I like to take an active role when I live in this country. So I just thought I should know the candidate.
You identified 2 groups there, a right-leaning group, is that correct?
It didn't seem to be like a political candidate type separation, but more of a right versus left. Yes.
Okay, so a right group and a left group.
Yes.
And you identify more with the left group.
I don't identify with a side. I was a registered Republican when I attended that day, but I don't necessarily ascribe to one side or the other.
After washing your eyes, you stayed in further back in Chapman Square, is that correct?
I actually crossed the street. There was a large sidewalk on the other side, and I stayed there.
After washing your eyes, you still stayed near Chapman Park.
Yes.
And you saw both groups kind of splitting off and going their general directions.
I only saw the right-wing group, really. It seemed as though the left-wing group had remained in the park.
You walked toward the group that was leaving.
No, I thought they had left.
You walked in the same direction as the group that was leaving,
One half of it.
towards Southwest 3rd and Madison.
Yes, I was heading towards the bridge.
You're heading towards the Hawthorne Bridge.
Yes.
You're heading towards Southwest 3rd and Madison, where the right-leaning group had just been.
Yeah, well, I'd seen them leave maybe 2 or 3 minutes, but all I could see was flags. I couldn't see actual people because it was in the distance.
They walked past Southwest 3rd and Madison.
I believe so, if I'm thinking of the proper crosswalk.
You specifically walked towards Southwest 3rd and Madison.
I believe so, yes.
Let me rephrase that. You were looking for a trash bin.
Yes. It was the one I remember seeing on my way over.
You bent down to tie your shoe.
I just had a rock in it. I was trying to get that out.
Okay.
Same thing.
You bent down to fix your shoe.
Yes.
Saw a group of half a dozen people to your left.
I didn't originally see them because it was on the other side of the bin when I was bending down, but I leaned back and I saw them once I heard some yelling.
You saw them yelling at Mr. Swinney.
I just heard yelling in general coming from that direction.
So it's your testimony today that you just heard general yelling.
It was definitely coming from those people, but I didn't hear like words or anything, just general yelling.
They were generally yelling at Mr. Swinney.
I just heard loud yelling, yes. I didn't see Mr. Swinney at that point. He was still behind a vehicle.
Page 22 of the grand jury transcript. Lines 17, 18, and 19. I'm showing you what's
I have terrible vision.
grand jury transcript from September 8th, 2020.
Oh, sure.
Invite you. You could just take a look at lines 17, 18, 19.
Okay.
So on September 8th, 2020, at grand jury, you testified that that group was yelling at Mr. Swinney.
They were once he stepped out.
But
I saw them before him, is essentially it.
on September 8th, 2020, let me rephrase that. You reviewed lines 17, 18, and 19.
Yes.
You do not state that Mr. Swinney stepped out into view. Is that correct?
In that, no.
You do not state that you didn't know who the people were yelling at. Is that correct?
In that, no.
Line 17, 18, 19, you stated in your testimony at grand jury was that those people were yelling at Mr. Swinney. Is that
Judge, I think this has been asked and answered.
We'll let her answer this one more time. They were yelling, and then Mr. Swinney stepped out, and that's who they were yelling at.
So, kind of going back to what you were saying earlier, you just testified moments ago that you had walked past the trash bin on Southwest 3rd and Madison on your way into the park.
When I was arriving?
Yes.
Yes.
And the snack block van, what corner
What's
was
that?
that on? The snack block van, the van, the you testified to a van?
Oh, the large white one.
Yes, the
Yes.
snack block van.
That was parked basically in the middle of like the long block, right on the sidewalk. There's a large boulder in the park that it was maybe 10 feet towards next to that, essentially.
And what corner was the garbage can on again?
Color I don't remember is dark, probably dark green or black.
Sorry, what corner was the
Oh,
garbage
the
can on?
corner. Sorry. It was 3rd and I believe whatever this cross street is, Madison, the one that empties out into the bridge.
3rd and Madison.
Yeah.
Kind of switching gears a little, you didn't know Mr. Swinney when you were at
No.
this event. Someone identified Mr. Swinney to you at the event.
Someone mentioned his name. I didn't know if that was the person they were talking about till I confirmed it online.
So after the event, you went home, is that correct?
Yes.
And after you went home, you looked him up on the internet.
I looked him up on my phone while we were still in the park. I saw the photo and it was unmistakably the same person.
That's all I have, thank you.
Any redirect?
No redirect.
All right. So, Ms. Stewart, you may step down. Thank you for coming.
Thank you, Your Honor. The state will call Officer Charles Ashheim.
Okay. Good idea. I'm gonna do that too.
Okay, heading up here. Raise your right hand, please. Under the penalty of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do so swear.
Now, seat there.
Thank you.
And if you could please state and spell your name.
Yes, Charles Ashheim, last name Asheim as in Michael.
Good morning, sir. If you are okay with taking off your mask, if you would please do so.
Yeah, I'm totally fine with that.
It is
Thank you.
okay with the court, is my understanding. First, I'd like to have you start off by telling us how you're employed.
I'm a police officer for the Portland Police Bureau. I've been a police officer in Portland since May of 2008. I worked for the Tualatin Police in Tualatin, Oregon from September of 2005 to May of 2008. So this September, I hit 16 years in law enforcement in the Portland area.
Okay. Any other particularized training prior to becoming a law enforcement officer?
No, I was in the military prior to this.
Okay, and we're going to be talking a little bit about firearms. So I want to understand a little more about your familiarity with firearms. So any training prior to becoming a police officer related to firearms?
Yes, I was in the United States Army for 4.5 years. My primary job was an infantryman. So my main job in the Army was working with small arms in a combat unit. So I certainly had exposure to different weapons in that time.
Now, as a police officer, I assume you get some basic training on firearms.
Yes, I attended the Oregon State Police Academy in 2005, where there's definitely firearm training specific to the weapons that you would use as a police officer. I attended the Portland Police Bureau Advanced Academy, which was 10 weeks long in the summer and fall of 2008, where again we had more firearm familiarization and training specific with weapons, that police use. And then starting in 2010, I was assigned to the gang enforcement team. Later became the gun violence reduction team. I'm currently assigned as an investigator to the enhanced community safety team. And so basically since September 2010, I've been assigned to a unit that primarily investigates gun crimes.
And in that approximately 10-plus year time period, have you had an opportunity to come into contact with firearms?
I've come into contact with easily hundreds, if not thousands, of firearms. During the time that I was in gang enforcement and then the gun violence reduction team, our team routinely seized 100 to 200 firearms every year off of subject stops, traffic stops, search warrants. We continue to do that in the unit that I'm in today, mainly under search warrants, and so a little different type of policing. But during that whole time, our job has been to investigate Measure 11 attempt murders, assist homicide with murders involved in firearms.
Okay, and what I want to understand from you is, do you in particular have familiarity with like revolvers and that particular, a particular subtype of firearms?
Yes, I've seen easily hundreds of different revolvers in the different investigations and stops that I've conducted in that capacity as a police officer.
And are you familiar that essentially, if we break it down, we start wide, there's rifles, there's shotguns, there's handguns, and then we kind of narrow it down into the handgun range. There's semi-automatics. There are even a few bolt-action pistols, very rare, but then there are what we call revolvers. Is that correct?
I agree with all that, yes.
Okay. And then to make sure the record's clear, just describe generally what is a revolver, how does it look, what are the basic components?
So a revolver, the difference between a revolver and a semi-automatic is that a revolver has a cylinder that contains the individual cartridges of ammunition or bullets. As you fire a revolver, there's single action, there's double action. Most guns are double action. That's kind of a more modern feature in most guns, but there are ones that are still single action. Basically, a revolver has generally a hammer that you can see. Sometimes there's hammers that are covered, but where in a semi-automatic, all the firing mechanism is contained in the upper slide, and the gun feeds itself after each fire based off gas pressure. Revolver is feeding itself by turning the cylinder as you pull the trigger back. There's a mechanism inside that turns that cylinder to feed the new fresh bullet. A semi-automatic also expends bullets out of the slide, out of the chamber after they're fired. A new round from the magazine gets pushed up into the chamber to fire the next round. Where a revolver has a cylinder that turns based off a wheel on the back of it, based off pulling the trigger mechanism and causing that cylinder to turn. That's what feeds the new bullet. It doesn't. They generally don't expend bullets. It's something you have to unload after firing it in the cylinder.
Okay. And you mentioned a particular terminology that I want to explore a little more. Can you explain the difference between a double action and a single action and what that means?
I would describe it as, so a single action is you are taking the time to pull the hammer back. So you have to put that hammer into battery. The hammer, when you pull the trigger, is just going to go forward, hit the firing pin, put the firing pin into the primer of the bullet, and which causes the bullet to leave the cartridge. A dual action or a double action, and on semi-automatics also, as you pull it back, the trigger is what's causing that hammer to go back and then go forward and hit the pin. Does that make sense?
I believe so.
Okay.
And some of these revolvers are either single action or this double action.
Yeah, I would say most of the revolvers nowadays are double action. Most guns are double action. It takes a step out of having to pull that hammer back, and you can fire the gun more rapidly. Single action, like if you think of like old cowboy movies where you'd see the cowboy like literally pulling the hammer back and firing from the hip, those are generally single actions. You're trying to get that hammer back. In a double action revolver, though, that has a hammer exposed, you can still pull that hammer back. So you can take it from the forward position to the single action position with your hand. And is what that does is it pulls the trigger a lot farther back. And so now you have a lot less pressure, weight, and distance to pull that trigger to cause the hammer to go forward. As you pull that trigger back on a double action, it's got to go through the whole cycle of like cocking the hammer back, and then it has to go forward. If you've already cocked the hammer, the trigger is farther back, and it's basically set, ready to fire, if that makes sense.
And then, did I ask you to review some photographs and potentially a video that related to an event on August 22nd, 2020?
Yes, you did.
We bring up State's Exhibit. I apologize.
Is it 36?
Are you familiar with this particular photograph? Shown as State's Exhibit 36.
Yes, this is one of the photos you sent me.
And based upon that photograph, are you able to see and identify the type of firearm that is being held in that photograph?
Well, there's many things that lead me to this conclusion, but I believe that that is most likely a Ruger Blackhawk 357 revolver.
Okay. And what leads you to that conclusion in that photograph?
In the photograph, well, it's clearly a revolver, so you guys can see the cylinder, you can see the hammer that's being held back by the thumb, which should tell me the gun's getting put into single action. Is why I believe it's specifically a Ruger is because of where the stamp is on the wood grip. That's where Ruger places their stamps, and I've seen other Ruger revolvers and other Ruger pistols that have that same stamping on it, as opposed to maybe a Colt where it'd be farther down in the center. It's right up there near the top of the grip, if that makes sense. And then that specific type of gun is one of those kind of unique single action only guns. Sometimes like Western or cowboy enthusiasts have them. People have them in collections. They're not a gun that we come across a lot on the street with the type of crimes we investigate, but I have seen these type of guns before. What's unique about it is it has the push rod underneath the barrel, which helps expel the rounds individually. It also has a pin in there that you would pull out to release the cylinder from the gun, where a lot of revolvers have like an arm and the cylinder stays attached. This one, you pull that pin forward and the cylinder actually fully comes out of the gun.
And were you able to locate a same make, model of gun as is pictured in State's Exhibit 36?
Yes, so I did some research in our property room. I called them and said, hey, do you have any Ruger Blackhawk 357s that are in police property that I could examine and see if it looks like what I'm seeing in this photo to confirm or tell me, no, you're wrong, it's something else. And our property room did have one from a case that was adjudicated in 2018. And I was able to go pull that gun, and it looks like the same gun to me.
And is that what you've brought here today?
Yes.
And Your Honor, the state's going to mark this as State's Exhibit 103 and offer this exhibit.
All right, and defense's instructions were on the record this morning. I assume he renews those now, and we will receive that.
Could you please remove that from the box?
Yes.
And the Ruger Blackhawk 357, to be clear, this is a firearm.
Yes, it's a firearm. My research of the Ruger Blackhawk itself is it actually is manufactured in up to 16 different calibers. And so, by looking at this photo, there's another photo you showed me where you can actually see kind of the width of the barrel and the cylinder. That tells me it's a larger round. A 357 is larger as compared to like a 22 or 25. And yeah.
Let me ask you this question. With the cylinder out, is it safe?
Yeah, so this gun is completely unloaded. There's 0 bullets in this box. They've been removed. There's no bullets in the chamber. There's no bullets in the gun.
And to be 100% clear, this is not the gun. You have no information that this is the gun, the exact gun that Mr. Swinney was holding that day.
I do not believe it is. It was recovered off a different person in 2018.
Yeah, so just same caliber, same manufacturer, same model.
Yes, being able to look at this and compare it to the photos you sent me helped me make this, decision that I believe this is likely the same gun.
Okay. And can you also explain how would you load this particular firearm?
Sure. So I'm going to take out this flag. This is just an evidence flag. Like I said, there's 0 bullets here. Nothing in this gun. I'll still keep it pointed in a safe direction, obviously. So this revolver, you have to pull this pin back by.
Made the witness stand.
Yeah, why don't you stand up just
Okay,
because
sorry.
that screen's blocking you and the box, shut
I'm
that
sorry,
box
guys.
top or move it so the defense can see. Please.
Is that better? So this revolver has a pin on the back here. You can see the same kind of pin in the photo below the barrel. So I'm talking about this area here. You push this pin, it pulls back. You have to open up this individual loading window, and then you drop the cylinder in like that, and you close the window. This gun, then you got to seat that pin back in. This one's having a little trouble seating. I don't know what the condition of it was when the police recovered it. So if I was going to load it, I would have pulled that pin out. I would have the empty cylinder. I'd put the individual bullets into the cylinder. It holds up to 6. Then I would pull that pin out, open that window, drop the cylinder in, and resecure it in the gun. Now I'd be ready to fire.
That would be one method. Would the other method be to pull that flap back and then kind of individually take them in and out?
Yes, so right here there's a window on the back of the cylinder where you can see actually the holes on the back of the cylinder. So each one of those holes is where I would take a bullet and I'd load, the bullet facing that way. So the back of the casing, the primer would be facing me, and it would go into here. And you can see you can turn it. You can, the other thing you can do with this gun is you can push this rod here, and this rod will force the last fired bullet out. So as that window opens up, it bumps it back forward, and then you can pull out like a fired casing, put a reloaded or live round in there. So you don't necessarily have to take the whole cylinder out to load individually.
Certainly. Would you just remove the cylinder for us, please?
Yes.
And then, and I don't know the answer to this question, but can you work the action without the cylinder in it?
I don't think you can.
Okay. Well, then I would like to see you work the action.
Okay.
If you can do so safely.
Again, there's 0 bullets in this gun. No way it can go off because there's nothing in it that can go off. So again, you open that window up. You got to get this pin forward. Pops back in. There you go. So you can see now this pin's all the way forward. That's what's holding the cylinder in place. So if I go like this on a normal double action, as I pull back, this hammer would come back. Does that make sense? It would come back, set. The trigger would be all the way back, and then I could fire quickly. It'd have very little space where you have to make that decision to fire. This gun is a single action only. As you can see, it's not going into double action. So what I can do though, is I can pull that hammer back to single action. You can see how far back it is, and now you can see how the trigger is much farther back in the trigger guard. And so with a little bit of pressure, in the firing pins right here, with a little bit of pressure, it goes forward. Does that make sense? On a double action, is what's unique about this gun is it can't go double action. Double action, like I said, would pull that hammer back as you begin to fire.
No further questions, Your Honor.
All right, thank you. Any cross-examination?
Yeah, I just have a few questions.
Yes, sir.
Is it Officer Rushheim or?
Yes, sir.
Okay. I think I need to. Sorry, I need to bring one more.
No worries.
Can you put that picture back up that you were just looking at?
The previous one?
Yeah, so in your evaluation, you were understanding that this was occurring on August 22nd of 2020?
That's my understanding, yes.
Sure. And beyond going and sniffing out a gun, you were involved in some of the follow-up investigation resulting from whatever happened on August 22nd of 2020?
Yes, that's fair to say.
Particularly, you interviewed.
You're going to object? Outside the scope of my examination.
I have him under subpoena. I can just recall him later. That's fine.
Okay. So then no questions with regards to his testimony
No.
So far, all right. So, then there's no redirect.
Nope.
So, officer, you are excused for the purposes of being a state's witness in this case, but you remain under the defense attorney's subpoena, and so, do you want him back this afternoon?
I mean, out of respect for his time, if we can go out of order, I have 3 questions for him. 3 or 4 questions.
Can we go out of order?
I think there would be a matter for the court if that were the case.
Okay, well then, why don't you step into the hallway? This is frankly probably a perfect time for a morning break anyway, so we'll take our morning break, give the jurors a chance to get their blood flowing again. We'll take up the matter for the court, etc. We'll have you back in here in about 15, 20 minutes.
Yes, sir. Are you fine with me securing this back the way it was packaged? Okay.
I also, Your Honor, have this lock that I brought as well. We'll put that through. And Your Honor, and with counsel's permission, we can discuss whether the court would like to store the gun or would like the state to safely store it. I mean, I understand why the jury has it, but I'm just saying general evening lunch, all that.
Probably best if you guys do. Unless the defense has an objection, in which case we can do it.
What I was missing.
Is it supposed to go back to the jury? Is that your thought?
It's been entered into evidence, so yes.
Yeah, I mean, we did abolish the difference between a demonstrative evidence and actual evidence a while ago. So there's no such thing as an exhibit that is demonstrative.
Yeah.
Reading the court's, or hearing the court's reading of the case law, the case law indicates that it could be received as an exhibit.
So the trigger lock doesn't fit.
No, is what I can do, Your Honor, is I can walk it through here, which will prevent the cylinder ever from being put in it, and I can put that zip tie back in the barrel to show that there's nothing in the barrel if you'd like.
I mean, at a certain, you want the jury to, I mean, there are multiple competing concerns for me. One of which is COVID and the jury passing around a lot of tangible objects.
You're right, it's okay. I'll withdraw my request to have it go back to the jury.
All right. So that's handled. So what is the matter for the court with regards to Ashland?
So it would be purely a hearsay objection to anything he would testify, because my understanding from the reports is that the only thing that he did was speak with Meg Stewart about some threats that she received after she filed her lawsuit.
There is a line on what is Bates stamp 201. And I actually moved in limine to not talk about threats, so I obviously am not going to go for those. But on paragraph 1, 2, 3, 4, the last sentence of that sentence, that paragraph says, she claimed to not even know what Antifa means.
Well, since he didn't ask her about Antifa, I don't believe that question was asked.
She said she's not politically involved, but she likes to be involved.
So she would have needed to be confronted with that statement before they can bring in extrinsic evidence to prove the impeachment.
I agree.
Okay, we're on the record with it.
Okay. So is that all you wanted, Officer Ashland? Okay. So does the defense want the firearm entered into the court record as an exhibit for the purposes of any appellate issues, or do you feel like the testimony and the record of the testimony is sufficient? I mean, the question is whether we're going to let just return it to
I was
PPB.
objecting to it come into the courtroom. The record is obvious that it came into the court.
Okay. So I don't know that we even, unless you want to keep it, Mr. Vasquez, for argument.
Yes, other than that, Your Honor, I will make sure that it is locked securely in the district attorney's office. And then if defense at any time wants to use it, I will certainly allow them access at any time.
Okay. All right. So I'll give the parties, does anyone, I mean, I assume,
Did Ashton leave already?
I think he's just right out in the.
do you need to grab him?
I mean, I have questions that don't elicit hearsay that I can ask him, that'll help.
Okay. I think I misunderstood, so hopefully he's right there. Okay.
Sorry, I was just making sure that he stays.
Yep, thanks. All right, so I guess I'm gonna use the restroom. We'll go off the record. If he says he still has questions for Officer Asham, I assume you don't care that we're gonna call him out of order.
At that part, I don't. I just,
Well, you guys talk about what he's, I mean, talk about it, and if there's more for me to decide, I'll decide it, but.
all right, thank you, Aaron.
Yeah.
Okay, sorry about that, everyone. I had some craziness I had to deal with in personal life. Um, yeah, I don't mind, as long as people are being respectful, not, spamming the chat or throwing up hateful, trollish comments, and we're just being respectful to each other. I don't mind, people of any ideology coming in. I just want to keep the chat civil. Um, and at this point, this is at the trial phase. They're anticipating the trial will be done by Friday, and Friday, Monday, sometime by then we should have a verdict from the jury about where the charges stand.
Very quickly, and then I'll let the parties make their record. The defense would like to call Officer
Go ahead.
Ashheim to testify that 6 days after the incident, Ms. Stewart told him she did not know who Antifa is or did not know what Antifa is.
No.
Okay.
I want to call Officer Ashheim and ask the question. Did you interview Meg Stewart as part of this case? Yes. Did she tell you things that happened on August 20, or did she tell you things related to that? Not asking for any hearsay. I'm just asking, did you have a conversation about the case with her? He will say yes,
Okay.
because it's in his police report. And then I've already asked for the less satisfactory evidence rule. Stating pain is an indication that the courts of appeals is, I'm not gonna say sick and tired, but no longer interested in the government eliciting all of picking inculpatory evidence, and then when the defense tries to put those in, they sit by and say, the evidence code prevents this. So I'll ask for.
Okay, so, and part of the problem is that of course, we had some of this discussion off the record, but I think for your record, you need to make this very clear. You want to call Officer Eschheim, you're going to ask him, did you interview her 6 days after the August 22nd event?
Yes.
And he will say, presumably, yes.
Yeah, well, he'll need to be refreshed. His recollection will need to be refreshed. He told me, but I have his.
Okay, fine. Sorry, I have fuzz in my mask. And then and then you're going to say, and you asked her about the events, and he's going to say,
Let me just make sure I'm looking at his police report.
Oh, we're also asking for witness.
Yeah, good point. I'm going to say, did you have a conversation with her about the various factions involved in the on August 22nd? And he will say yes. And that's it.
So I guess it would be relevance and hearsay. I mean, the issue is so to do this properly, what they would have had to have done is say, so, Ms. Stewart, do you believe, did you know who Antifa was at the time? And she would say, yes, I did, or no, I didn't, or this or that. And then you would impeach them with a prior inconsistent statement. But none of that's been done. So the Court of Appeals has not come out with an opinion, to my knowledge, that says that they suspend the entire evidence code.
but okay, two things. I don't think he's intending, I don't actually understand why you're intending to offer it, which probably goes to the relevance piece more than anything. So.
We've already requested the less satisfactory evidence. What will be present in front of the jury is that there is information and evidence about this that was collected by the government that was not presented to the jury. I'm not impeaching her, I'm impeaching them. And if there's a basis in evidence to get that instruction now, it's no longer the case that less.
No, I understand that.
Yeah.
I just don't. So, okay. Stepping back. Well, okay, say what you're gonna say, Mr. Vasquez. I don't
even know how this goes to less satisfactory evidence. I wouldn't call in the officer to say, hey, did you talk to Megan Stewart? Hey, could you tell us everything that was said? It's just, I couldn't do that because that's hearsay.
Right.
And so that doesn't go to being less satisfactory evidence. So even if assuming that defense is correct on this, which I do not agree with, that wouldn't even prove their point because it's not something I could do. So this is going to do is tend to confuse the jury because, it's like, hey, did you give a statement? Well, okay, what is that even in reference to? Like, there's no context. There's nothing to link it up. There's nothing like, hey, she made an inconsistent statement or anything of that nature.
And do I understand that primarily, and I think this was said off the record, and so I want to make sure if I'm wrong about this, I want that clear. Is the interview 6 days later related to the threats she received because she filed a civil lawsuit?
That's the state's position, yes.
And the defense moved in limine prior to trial that they would object to any of that testimony coming in, right? Am I remembering that correctly?
That is all correct, Your Honor.
Okay, and so, go ahead.
Relating to the threats, the statements made to Meg Stewart saying we are threatening you, not relating to other exculpatory statements that she made.
And what's exculpatory?
I just don't believe it for a second. And if the jury gets that, then they're.
But you have already said you're not going to ask her, or
Right, and the ship has sailed on us being able to impeach her with it. We didn't ask her about it on trial. But the government now objecting to it come in. First of all, does Mr. Vasquez really think that something that he obviously thinks is exculpatory because he's objecting to it coming in, does he think that I would make a hearsay objection to him saying, hey, did Nick Stewart say these things?
okay, I am more confused than I was when we started this. So you want to call Officer Ashheim and you're going to say, did you talk to Megan Stewart 6 days later? Yes. Did she make statements to you about the incident? Yes.
The factions that are involved in the incident.
Did she make statements to you about the factions that were involved in the incident? Yes.
That's it.
I mean, how is that relevant?
It's relevant to my request for the less satisfactory evidence instruction.
Well, okay. I understand that you're saying, I mean, I just don't think you can have it both ways, because what you're saying is, I assume you want to argue to the jury, and Ms. Stewart was also interviewed by Officer Ashheim. You heard that, but you didn't hear anything that she said to him. Is that what you're going to essentially argue to the jury and then ask me for the less satisfactory evidence?
I'm not going to argue that to the jury if it's not in evidence, but I will argue that to the jury with regard to a less satisfactory evidence instruction.
And the interview itself was, by the state's interpretation, contents that you moved in limine to exclude.
If the state misunderstood my motion in limine to exclude, I mean, I guess I wrote it down.
So Your Honor, the officer responded to Megan Stewart because of the threats. That's why he was there. Yes, he talked to her to get context, like you would anticipate anyone would, to understand the context of why she's calling. It was the threats, the very thing that he requested, the threats related to the lawsuit, the very thing that he requested we not bring in. So there are multiple levels why defense arguments fail, but that's certainly one. The next is that the way in which they're going about this, it doesn't connect in the relevance and the logical chain. There's just multiple ways, and it's in the end, the state objects.
I truly desire to give great latitude to the defense to make their case, but I fail to see that there's anything relevant here. So, if that's all that you wanted to call Officer Ashheim to do, I am going to exclude it.
I'd like to make an offer of proof.
Okay, fine.
Would you like Officer Ashman?
Yeah.
And then after this is all we have the phone calls?
Yes.
All right, welcome back, officer. You're still under oath.
Yes, Your Honor.
This is what we're doing is just called an offer of proof so that the defense can put on the record what they would ask you if I would allow them to.
Okay.
Okay.
Do we need to swear him in?
I said he's still under oath.
Oh, okay.
Officer, I'm handing you a copy of what I believe to be a report that you wrote September 2nd of 2020. Do you recognize that?
I do recognize it, yes.
Okay, and you wrote that report?
Yes, I did.
Okay, and this is in relation to the events. Well, you interviewed Megan Stewart.
Yeah, there was a phone call that I responded to.
Okay,
Yeah.
it was a phone interview.
Mm-hmm.
And did she make, and before I even ask you, I'm just going to be asking you with regard to that right there. Did she make statements to you relating to the various factions that are involved in these types of protests?
Yes, she did.
Thank you, that's all.
Okay. Any cross?
Just briefly. Do you I have to bring this over here? I have a copy of your report. I apologize, but it's here on the computer. Does that look like your report, Officer Ashheim?
Yes, it does. It's the same one, just on a computer.
On the computer. Okay. And what was the reason why you went to the call?
It was a phone report. Saying, I'll just read the notes. It says, take by phone, complainant filing civil suit against Proud Boys. Attorney went public without her knowledge and now is receiving multiple death threats on the internet. Hasn't slept in 2 days. Wants police to know she isn't a protester. Has specific suspects.
Okay. And so was your purpose in taking that report to understand the threats that were being made to her?
It was to document, yes, what she was saying she believed she felt threatened, and document in a police report what she thought, were threats and what was happening to her.
No further questions.
Redirect?
Sure. Officer, when you conduct an investigation, is it true that every single time that you conduct an investigation, the topics of conversation are specifically limited only to what the call of the question, so to speak, is?
No, a conversation can definitely go outside of the original scope of a call.
No further questions.
Okay. And so, to the extent I need to restate it, I don't believe, so if Officer Ashheim came in to testify merely that he interviewed her 6 days later and she made statements to him about the factions, without further context, which would be hearsay and or improper impeachment of Ms. Stewart's testimony, I feel that this information only serves to confuse the jury, and it has, I don't even know that it meets the basic 401 threshold of relevance. If it meets 401's threshold of relevance, then I also find that it is not admissible as unduly confusing to the jury without greater context, the greater context of which was in part not pursued with the witness because of a defense motion in limine regarding the lawsuit and the threats surrounding the lawsuit, which was the primary purpose of Officer Ashheim's interview of her. Thank you, Officer Ashheim. I believe that means you are excused.
Thank you, Your Honor.
Here you go.
And we're gonna go get the jury.
Thank you.
Since all we have left is the 3 calls, I imagine you'll have do you guys have a witness ready to go? Or should we?
I had 2, but I can try to add them earlier.
Well, no. We can play the 3 calls. And we can excuse them early and just come back at, I'll make you guys be back here at 12:45. So, and then have them, actually I'll have them back at 12:45 too, so we'll just take an earlier lunch. Rather than you stress and try to get witnesses here that then you're gonna potentially wanna talk to anyway.
Okay, yeah, but I had said they would come at 2.
Do you
Get them here at 1.
want to, there'll be motions, I assume?
Yeah, that's why I'm thinking. So we'll break them early for lunch. We'll do whatever defense motions need to be done at the conclusion of the state's case.
We just have to go get the jury and I need to call my investigator.
Okay.
But why?
Because I told her 2, not 1, because I didn't.
We could do that over the lunch hour, though.
Okay, I'll just.
I mean, you can, there's going to be 3 phone calls and the state's going to arrest. You can call her. Right?
Yes.
Yeah.
Nothing exhibits.
Yep.
Oh, I better get my notes here.
And I may ask for 10, 15 minutes to prepare my thoughts for my motions so they can be hopefully more articulate.
Great. right, members of the jury, just to give you a quick roadmap of how we're going to spend the rest of our morning. The state is in just a moment going to play State's Exhibits 90, 91, and 102. Those are phone calls of Mr. Swinney made sometime after the August 22nd, 2020 incident date. Once we're done with that, I believe the state will rest.
That's correct.
And then we're going to break early for lunch today because the attorneys and I have some matters we need to take up before the defense case begins. So we'll break for lunch probably at about 11:15, which means I would like you back in the jury room by 12:45. So we'll have a longer-ish lunch, but still come back a little bit earlier so that we can get rolling early in the afternoon. Okay? All right. State may proceed with its exhibit.
Thank you, Your Honor. I believe there was also a statement from the court about the exhibits.
Well, I made it.
Did you? My apologies. I was paying attention to a couple things.
Yep.
All right, we'll start with our exhibits.
All right.
So we'll publish number 90.
Okay.
Wasn't who shot the girl with a paintball.
Just the volume real quick.
Wasn't me who shot the girl with a paintball. Did she deserve to get shot with a paintball? Yeah. She's in a violent mob, right? So, like, I mean, that's what happens to you when you get mixed up.
Is there a way to turn it up?
Possibly.
I can try and
Yeah, I think I'm all the way up on the computer side.
try again.
Trying again.
Wasn't me who shot the girl with a paintball. Did she deserve to get shot with a paintball? Yeah. She's in a violent mob, right? So, like, I mean, that's what happens to you when you get mixed up in violent mobs, right? Did she deserve to get shot with a paintball? Yeah. Am I glad she got shot with one? Yeah, I am. And that guy that got hit in the eyebrow, like, I told him to get away from me several times, and he wouldn't get away, and he was blocking somebody who was coming up to us, who was sneaking up behind him to assault me, and he incidentally got hit with a paintball in his eyebrow. Too bad for him. He doesn't need to be hanging out in violent mobs. He's lucky the guy behind him didn't throw a Molotov cocktail, because if he did, it might not have been a paintball. It might have been something else going through there. So, I mean, he should consider himself lucky, and he should quit hanging out in violent mobs, right? So, like, both of those.
That's State's Exhibit 90, publishing State's Exhibit 91.
That girl that got shot in her titty with that paintball, that wasn't my paintball.
She can't prove that was you.
No, right, but yeah, she can't prove it was me. And Eyebrow, there's a reason why he got shot with that. There's a reason, and like he should be thankful, and he should use that as a learning experience, right? Because if the guys behind him were throwing Molotov cocktails, then it wouldn't be paintballs. It would be live ammo, right? Because like I'm not gonna sit there and let somebody throw Molotov cocktails at me or shoot at me because there's some dumbass standing in between us, right? So, like, yeah, he needs to, he should use that as a learning experience. And the only thing I need to hear out of that motherfucker is a thank you, right? Because I'm handing out life lessons to him.
And publishing State's Exhibit 102.
Proud of every time we kick their Antifa's ass, too, because they're enemies of this country. They're enemies of the Constitution, and they're domestic terrorists. And I don't care what anybody thinks about that. I hate them. And I'm going to do everything I can to bring them down every chance I get. So I don't care what anybody thinks about that. It doesn't matter to me. It doesn't matter to me. And of course the left's going to hate that.
Okay. Did everybody hear that? Okay. I think we have these other speakers, but I'm not sure they're working right, that we're hooked into them correctly. But everyone heard it okay?
The first one was a bit faint.
Okay.
I found it hard to understand.
Okay.
gonna try a different application that might play a little louder.
It wasn't me who shot the girl with a paintball.
I don't know if that's gonna be true, but I can try it again. So this is, for the record, State's Exhibit 90.
It wasn't me who shot the girl with a paintball. Did she deserve to get shot with a paintball? Yeah, she's in a violent mob, right? So, like, I mean, that's what happens to you when you get mixed up in violent mobs, right? Did she deserve to get shot with a paintball? Yeah. Am I glad she got shot with one? Yeah, I am. And that guy that got hit in the eyebrow, like, I told him to get away from me several times, and he wouldn't get away, and he was locking somebody who was coming up to us, who was sneaking up behind him to assault me, and he incidentally got hit with a paintball in his eyebrow. Too bad for him. He doesn't need to be hanging out in violent mobs. He's lucky the guy behind him didn't throw a Molotov cocktail, because if he did, it might not have been a paintball, it might have been something else going through there. So, I mean, he should consider himself lucky, and he should quit hanging out in violent mobs, right? So, like, both of those.
Okay. They are on those other speakers, so just pretty faint. Okay. Mr. Vasquez.
Yes, Your Honor, with the understanding that those 3 exhibits have been accepted by the court, the state does rest at this time.
All right, those are received. The state has rested. We're going to break for lunch. Back in the jury room at 12:45, please. All right, and Mr. Westover indicated he maybe wanted 10 to 15 minutes to gather his thoughts.
Yes. Would you like to have us step out while you do that? Sure, I'm just gonna be. Okay, we'll work here then.
So we'll just go off the record and.
Okay.
Now we're specifically talking about counts 7 and 8 for the record, those occurring on August 22nd, count 7 being the paintball gun and count 8 being the revolver.
So certainly for the second one on the paintball gun, we'll go with the same possession with the intent to use unlawfully.
So, and I'm sorry, the unlawful use with a firearm is count
8.
And I don't have the indictment right in front of me, Judge. Do you mind reading that?
This, yeah. It's the said defendant Alan James Swinney on or about August 22nd, 2020 in the county of Multnomah, state of Oregon, did unlawfully attempt to use, carry with intent to use, and possess with intent to use unlawfully against another person a revolver, a dangerous and deadly weapon, contrary to the statutes in such cases made and provided and against the peace and dignity of the state of Oregon. The state further alleges that during the commission of this felony, the defendant used and threatened the use of a firearm revolver.
So on that charge, because there's essentially in evidence, there's one instance of him actually pulling the firearm out and pointing it at various individuals, including Ms. Carell. That would be essentially the election for what would be a specific instance of attempt to use the firearm.
Okay.
But there's still a remaining theory of, a simultaneous theory of possessing it with the intent to use throughout the events of the 22nd. It is a dual theory.
Well, okay, so then at some point, does the jury not have to be instructed that they either agree? I mean, I guess they can agree on
Either or both. I mean, they
either
would
or
have to
both.
agree to either it's one and not the other, or that it's both.
And we'd
be arguing it's both.
We would request a concurrence instruction and maybe also on the verdict form indicate separate ones.
We're going to be requesting a general verdict form with interrogatories for pain, which sounds similar to what they want. But I think, for the record, I believe they have to further narrow it.
What?
I mean, actually, never mind.
Okay. All right, motions for judgment of acquittal. Do you want to go count by count?
Yes.
Okay.
Well, I'll start by, let's see, talking about, and I'm going off of, I'm sort of using my requested jury instructions. We have, which I may have printed up an old version when I brought in, but in any case, we've got this count 1, attempted assault in the 4th degree. The state has previously elected that is, they described, I believe, as a woman being sprayed in the face with mace. I suppose we'll concede that there is evidence to go to the jury that this act occurred on or about August 15th of 2020. Intentionally attempted to cause physical injury to another person. The state, so obviously that must be Mr. Swinney's conscious objective to cause physical injury. Physical injury is defined by impairment of a physical condition or substantial pain. There's nothing in the record right now, in the light most favorable to the state, that Mr. Swinney knows that it will cause physical injury to the level of substantial pain. We've got, and I believe there's a case, I think it's called State v. Renner. I can find the citation for Your Honor if you'd like. But essentially that was a case where somebody had been kicked. the evidence was they had been kicked. That person was not available. That person was available at trial, but that person. Hold on one second. That person was available at trial, did not testify that it hurt. There were, however, photographs of the results of the kick. And the photographs, which I believe showed bruising, the Court of Appeal said that is enough to show pain. A jury can infer pain from that, but they cannot infer substantial pain. And that is the problem with the state's case here. I assume if they had their witness, they would have probably charged assault in the 4th degree. But in any event, just because if they can't prove physical injury merely by showing photographs of bruises, then they can't show somebody's conscious objective to cause physical injury simply because that person is seen pointing the spray bottle at somebody else's spray. The state has also failed to disprove beyond a reasonable doubt in that case that Mr. Swinney was acting in self-defense or defense of others. What we have up until that point on video, objective evidence of Mr. Swinney beginning to the extent that there's a statement from Mr. Swinney earlier to Jason Britton, yeah, I'd like to shoot you. Nothing is said about mace. Mr. Swinney and his group are followed, continuously followed. They stop at several points. Mr. Swinney does say, I feel threatened. Mr. Swinney says, back, 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 and is gesticulating with his mace. There is a point early on in the Stumptown Matters video where a man gets very, very close to Mr. Swinney, and he turns around and he shoves that man with his elbow. These are all indications that Mr. Swinney does not want these people to get close to him, and he is using different tactics in order to keep people away. Jason Britton testified that it is important to not allow people to get too close to you and to not allow them into your group. And so Mr. Swinney stopping at that point, there is a hostile crowd behind him that is several feet back from the individual alleged in count 1, but that individual has encroached further into Mr. Swinney's area towards his group. That is a perceived threat. This is a reasonable response. The state has not disproven that.
Mr. Vasquez or Schweitzer.
You're right. I think counsel is overstating what State v. Renner goes towards and what it says. And there, essentially, there's no testimony about kind of that substantial pain. And so it would be one, certainly if we were here talking about an assault where there was injury, and we were there, which we will be on other counts, then if the state had to prove the injury, maybe State v. Renner would be relevant. However, in this case, it's an attempt to cause injury. There's plenty of other inferences that can be drawn from Mr. Swinney's actions that day, about his intentions, and this is him taking a substantial step towards spraying someone in the face. There are common sense inferences that can be drawn. So that's where it would go for count 2, which is, I believe, where we're at.
Count 1 on physical pain, but and then anything you want me to consider with regards to whether or not the state has met its burden on self-defense / overcoming the self-defense.
Yes, Your Honor. The court heard substantial testimony and information about the social media posts, the things that would strongly indicate that Mr. Swinney was the initial aggressor. In that, additionally, whether or not it was a reasonable approach to spray someone in the face who was unarmed, standing in front of them, not saying or gesticulating or doing anything, if that's reasonable, that the state would submit that as not a reasonable use of self-defense. Similar to the second, we're not on that second man, but that evidence combined with all of the way he presented and handled himself that day would go against self-defense.
All right. With regards to count 1, attempted assault in the 4th degree, I find that there is sufficient evidence in the light most favorable to the state that the female on 4th Avenue who was sprayed with mace, that Mr. Swinney was attempting to caused pain by deploying mace on her at the short distance that they were. And I do not believe that self-defense was an issue. Count 2.
You don't believe self-defense was an issue at all? Or that there's...
Well, in the light most favorable to the state, I believe that they've overcome their burden.
Off the use of the mace in the second degree. It's the same instance here, same argument with regard to the mental state. In this case, it is a recklessly standard. Well, we'll rest on the self-defense aspect. I suppose I don't expect Your Honor to apply this to the previous argument, but I will also note that the delivery of the of what has been alleged to be mace to the person's face is a very short burst. It is not a continuous spray. It is a quick pop, get away from me.
Okay, well, I assume the state is just, well, does the state have anything else to say beyond what they already said?
I would only refer the court to the state's exhibits that presented the pictures and photographs of the event that show the woman being sprayed in the face.
I agree. I think in the light most favorable to the state, count 2 can go to the jury. There is enough evidence that contradicts a self-defense, or there's enough evidence that the state has overcome its burden to disprove it. I'm not being very articulate, but in any event, count 2, motion for judgment of acquittal is denied. Count 3.
Attempted assault in the second degree. I understand that this relates to a person that is seen on video holding what witnesses have testified is a camera, and that Alan Swinney shoots his paintball gun at that person and hits them in the mask. So his intent would have to be, it must be his conscious objective to cause physical injury to another person in this by means of a dangerous weapon. And so, first of all, shooting somebody in the mask does not suggest an intent to cause physical injury. Masks are there to prevent physical injury. If there had been some suggestion or anything on the video, if Mr. Swinney had shot multiple times, demonstrating a desire to hit multiple parts of the body, or had shot the person in, for example, the torso or the leg, something that was unprotected, then there may be evidence of a conscious objective to cause a physical injury. However, because it was a directed shot right at the mask, that evidence is just not there in this case. The state, because of the way that an assault in the second degree works, the mental state ties both to the intent to cause physical injury, but also with a dangerous weapon. We're in Simonov grounds here. I have a memorandum in support of my jury instructions with regard to that. So not only must it be his conscious objective to cause physical injury, it must also be his conscious objective to be using a dangerous weapon to do so. There's no evidence that Mr. Swinney contemplated his use in that case of a paintball gun as a dangerous weapon. And dangerous weapon, as it is defined, is any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, intended to be used, or threatened to be used, is readily capable of causing death or serious physical injury. So death is obvious, but serious physical injury is protracted disfigurement. Let's see. Serious physical injury is a physical injury but amplified, which creates a substantial risk of death, or which causes serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. First of all, using it to shoot somebody in the mask does not indicate a conscious objective to be using that weapon as a dangerous weapon. It can't be contemplated that a person who's shooting somebody else in the mask goal is to cause serious physical injury, which is what would be required from the evidence here, and we're just not there with regard to that. Similar argument as it relates to whether the device as used, they can fail on intent, but they can also fail on, even if you found that the person had the intent to use it as a dangerous weapon, you look at the circumstances of its use, and for this count, you cannot conclude that as used, shooting somebody in the mask does create a substantial risk of death or serious physical injury. The state has also failed to rebut the self-defense or defense of others, the defenses that have been raised.
I'm glad we're all equally inarticulate about how to say that. Okay.
And if I could just cite, I did pull a cite on the dangerous weapon standard. Looks like 288 or App 721 State v. Ford. That talks about it's the circumstances of use, not the design.
288 or App
721.
Okay. All right. State.
First and foremost, the state disagrees with counsel's recitation of the facts, that this is one in which he actually shot him in the head, not in the mask. And that is evidenced both by the video, but also by the fact that you hear him grimacing in pain as he is going away. So there's a strong disagreement there. But even if the state doesn't, even if it were that he shot him in the mask or intended to, this is still a very dangerous conduct. He's shooting someone in the head, in near the eyes. Whether that mask was going to stop it or not, that can't be known because it hit him up high versus in the eye. It is the activity that he is engaged in, and it is an attempt. He is taking a substantial step towards. Shooting someone in the head could certainly cause concussion and other types of injuries, and those inferences can be drawn. Certainly we know from other evidence in the case that it caused a long-term protracted injury in that Mr. Britton was hit slightly over in the eyebrow, and it caused and then within the eye cavity a bit, and it caused his eye to be damaged for a long period of time. We're here 1 year afterwards, and he is still suffering consequences of that assault. So I would say there's substantial evidence. Certainly, I would forward my previous arguments about self-defense as well.
All right.
Do I need to respond to that?
I mean, if you need to make more of a record.
Sure. First of all, with regard to the mental state, this count predates Jason Britton being hit in the face. So in terms of what Alan Swinney's knowledge, intent, or whatever, he can't have, his intent cannot have been motivated by something that has not yet happened. Second, Mr. Britton was incidentally hit, and he was not wearing a mask. While being hit in the eye may cause a serious physical injury, there's no, what we're talking about here is, sorry, I forgot the phrase. The phrase is readily capable of causing death or serious physical injury, and it's just not capable of doing that when there's something that's going to prevent it from going into the eye.
All right. The state's theory is that it didn't hit the mask, that it hit the head. I think that for that reason, in the light most favorable to the state, count 3 can go to the jury. I believe that the state has shown there's sufficient evidence to show that the defense of self-defense doesn't apply to this instance as well. And I think that pointing a paintball gun at someone's head or face, whether they're wearing a mask or not, with regards to the use theory that the defense has forwarded, again, in the light most favorable to the state, the paintball gun was a dangerous weapon as used with regards to count 3. Count 4, unlawful use of a weapon for general things on August 15th.
I have a preliminary argument that will apply to every unlawful use of a weapon charge.
Okay.
And that argument is by reading the plain language of the statute, and it's in the context and the obvious meaning of the words, there is something akin to an imperfect self-defense with regard to an unlawful use of a weapon. In order to be guilty of unlawful use of a weapon, it is a specific intent crime, regardless of which prong the government is proceeding on. It must be the person's conscious objective to be using that weapon, but it must be that person's conscious objective to be using that weapon unlawfully. And so, to the extent that we have the evidence in this case in terms of what we're looking at, even if you believe that Alan Swinney was not intending to use the weapon unlawfully, then right there, the case is done, or that count is done. There is also, they have failed to rebut the self-defense claim. There's also, and then it's I will say that I'm not conceding the state's argument at this point is carried with intent possessed with intent to use unlawfully against another person. I do think that they need to articulate who that person is, and they have not done so. So with regard to that, they have not failed another person. I cannot remember that. I didn't have time to look up citations during this morning, but there is a case where, for example, a person shooting, it's a civil case actually, but a person shooting a firearm, essentially the old Wild West thing, seemingly of go a dance, buddy dance, shooting at the ground in front of them, that does not constitute the crime of unlawful use of a weapon because the use was at the ground, not against another person. And so there does need to be a tie between the carrying and the use of against another person. Because of the nature of unlawful use of a weapon, it is also, this is another reason why they do need to elect further as particular in terms of another person, because it has to be with a dangerous or deadly weapon. And so if my intent is to go down to a rally and shoot every single person I see there with a paintball gun, somebody there might be in one of those crazy suits that you can attack by a bear and not have any damage. I can shoot that person all day long, and as used in that case, it's not readily capable of causing any injury whatsoever, let alone serious physical injury. And then we saw the video of that woman standing on the rock there. I could shoot that lady, and that's going to cause physical injury. So without a further election from the state and on those grounds, essentially with regard to all of the unlawful use of a weapon charges, we'd ask for the court motion for acquittal.
Okay, Mr. Vasquez.
Sure, certainly I would say that the evidence, such as a social media post about his desire to engage in civil war, evidences and would be an inference of which could be drawn that he came down with the specific intention to harm others, and that then further is played out by his use of the paintball throughout the course of that day.
Okay, so, and I will say, I assume you're relying on your filed motion with regards to whether or not you need to name a specific person or identify a specific person?
Yes, Your Honor.
Okay. I agree that a particular person for the purposes of unlawful use of a weapon does not need to be identified. And so the motion for judgment of acquittal / motion for further election is denied. With regards to count, now I'm losing track of counts. With regards to count 4, and to the extent that count 7 and 8 are also implicated here, I believe that the evidence the state has presented gets them past the motion for judgment of acquittal with regards to Mr. Swinney's intent to use the paint gun unlawfully against another person, and the revolver unlawfully against another person. And I believe there is sufficient evidence rebutting the self-defense claim that counts 4, 7, and 8 can go to the jury. Count 5.
I will have some additional argument in terms of the revolver. Probably I'm going to ask for an exhibit to be played. And I can talk about, or I can ask your honor to review some exhibits, but if you were to review the video, you've watched the video presumably once or however many times it's been shown here. We've been watching the videos over and over and over again. And so what we see with regard to Jason Britton's case is Jason Britton is part of a crowd where he is one of the most hostile members. Alan Swinney basically pays him no mind with regard to the language he's using. If you look at the Stumptown Matters video, when the camera person is rounding the corner to turn right onto Yamhill, two men appear in the video. Both of those men are wearing gas masks. Both of those men are wearing white, what I will call white beater shirts. And both of those men have backpacks on. If you follow the camera, there's Jason Britton's video around that same time, a little bit later, shows Alan Swinney turning around and firing his paintball gun at a man who is very clearly holding an asp baton, an extendable steel baton. If you line up those two videos together, you have Alan Swinney shooting as soon as he's starting to shoot, and his group starts to pepper spray the man with the baton, who, it works, he turns around and he walks away. As soon as you start to see those two gentlemen with the white beaters pop back against the wall. They see that he's doing something to somebody, and they essentially hide themselves. They then continue on, and if you continue to watch the Stumptown Matters video, you can see those gentlemen coming up behind members of Alan Swinney's group. Alan Swinney, if you look at the very first frame of Jason Britton's shortened version, one of those men is in the frame. His left shoulder is in the frame, and you can see Alan Swinney looking back and ultimately start shooting at that person. This is all stuff that Alan Swinney is aware of. And then if you look at the ultimate fact here of what is going on in terms of the shooting of that person, first of all, the video and one of their screenshots shows Mr. Swinney, and Your Honor, if I could just look up at me, because if you were the position of Jason Britton filming, Alan Swinney turns around and says, "Back, back, back." He is not pointing at Jason Britton. He is in fact pointing, the other videos will show, at that same person who's been tailing him and aggressively approaching other members of Mr. Swinney's group. And Mr. Swinney has already identified, because he's already been shooting at that person, to stay back. So with regard to self-defense, Alan Swinney is engaging in self-defense at that point, and the state has made no effort to rebut that. We also have Jason Britton's testimony in this case, his own testimony, which he said in the interview right after this happened. He said Alan Swinney was shooting at a person to my right. It cannot be shown that, and you watch the video, that person begins to drift over. Alan Swinney is continuing to shoot at that person
the hit on Jason Britton, even per his own testimony, is at best incidental, that's at best reckless, and a person cannot commit the crime of assault in the second degree as charged with a reckless mental state.
So again, the evidence that we're looking at both is the social media postings of Mr. Swinney to start, and then from there, we go to Mr. Britton's video where he actually talks to him about the paintball gun and asks him, do you want to shoot me with that? And he says, yeah, I kind of do. So some evidence there. There's another time where they talk and they have an interaction where Mr. Swinney talks to him. That's on 2nd Avenue. And then certainly there's that chattering back and forth. And in fact, in the video, what causes or what appears to cause or what happens immediately prior to Mr. Swinney turning around is that he talks about, calling the police and he's going to hold him accountable. And this, you see, immediately when he says that, Mr. Swinney turns around and holds up the gun and starts yelling. Now, certainly, there is the young black man who's clapping his hands loudly. The state would submit that that is not reasonable for Mr. Swinney to then shoot him in the face or attempt to shoot him in the face because he was clapping his hands loudly. In fact, he doesn't really even start to advance until Mr. Swinney puts the gun up and starts shooting him. Is it that he specifically had the very specific intent to shoot Mr. Britton, or was he just shooting the young black man in the face? Either one would constitute the crime of assault in the second degree, as the state is requesting, and will request that the jury, on a concurrence instruction, find either that he was specifically intended to shoot Mr. Britton, or it was a transferred intent. He was shooting at the young black man, and through that, the intent transfers over to Mr. Britton.
I mean, with regard to the transferred intent, somebody in their office came up with this a short time ago. It was argued in front of another judge last week on a harassment claim. The case that's very helpful is State v. Wesley, 254 4F 697, that talks about there being a principle of transferred intent with regard to murder in the common law and the establishment of the modern criminal code, not abolishing the principle of transferred intent with regard to the now statutory crime of murder. And if you go read the case, it has everything to do with the fact that there's this thing called felony murder, and it's just not a principle that exists in criminal law. In fact, it's why we have mental states. And I just disagree. I don't think that any reason, in terms of who he was shooting at, I don't think that any reasonable juror, even in the light most favorable to the state, even with the parlor posts, could conclude beyond a reasonable doubt that Mr. Swinney intentionally or knowingly caused physical injury to Mr. Britton with a dangerous weapon.
Okay, well, I think for the purposes of motion for judgment of acquittal, for all of the other reasons we've already stated on the record, there is evidence sufficient to go to the jury. I would note that my recollection and my notes of Mr. Britton's testimony are, I could have been shot accidentally, but it may have been intentional. So Mr. Britton himself wasn't sure whether or not Mr. Swinney shot at him. I'm not prepared right at this moment to address this transferred intent issue and concurrence instruction issue. So I'm prepared to let that go to the jury at this time. Count 6, the assault in second degree with regards to Ms. Stewart.
Same arguments with regard to, first of all, there's an identity problem here. Second, the videos that you watch, Alan Swinney, the videos that they have, any video that actually, the main video does not capture Alan Swinney shooting his paintball gun. The videos that do capture Alan Swinney shooting his paintball gun are all peppered with, you can hear sounds of clack, 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 which, as Connolly talked about, being tasers being brandished. She didn't identify which side was brandishing the tasers, but there's always something close in time with Mr. Swinney's shooting of his paintball gun that suggests that there is some sort of self-defense going on, and there's once again no sufficient evidence that he intentionally or knowingly caused physical injury to Ms. McLean.
Ms. Stewart.
Depends on which day of the week it is.
Well, she's named as a complaining witness of Megan Stewart in this indictment, and that's how we're going to be referring to her. And this is, again, the unnecessary snark that hurts to wear this court down. So, with regards to count 6, assault in the second degree, what does the state have to argue?
Ms. Stewart specifically testified that she saw Mr. Alan Swinney shoot her with the paintball gun. I believe that fact alone, that testimony alone, would substantiate that. For all of the reasons stated previously on the self-defense, both his intent coming into that day, making him an initial aggressor, and all the other reasons stated by the state, and the fact that she was, by all accounts, wholly unarmed and uninvolved in the sense of engaging with him, other than he decided to shoot her because she had a camera, the state would request that you deny the motion.
With regards to count 6, assault in the second degree, Ms. Stewart did in fact identify Mr. Swinney as the person who shot her, and I do not believe that she was a threat to Mr. Swinney, so at least in the light most favorable to the state, so count 6 can go to the jury. Do you have additional argument on count 7, or are we okay there?
No additional argument.
Okay.
My same arguments with count 4 relate to count 7.
All right, and so for the rulings I made with regards to count 4, I will allow count 7 to proceed as well. Did you say you had additional discussion as to count 8?
Yes.
Okay.
Mr. Swinney pulled his firearm out and pointed it at a group of people. I would ask Your Honor to review the evidence as well. Not only, and what was her name, Ms.
Carell.
I always want to call her Connolly.
Yeah.
For some reason, Ms. Carell testified that she witnessed all of a sudden everybody that was holding shields and directly in front of Mr. Swinney, all of them simultaneously ducking. After that, Alan Swinney pulls his gun, and if you review those videos of him pulling the gun, you've heard his voice a number of times in other pieces of evidence where it's undisputed that it is him. You hear him say, "Hey, hey, hey." He has pulled his gun. People are shooting projectiles at him. Ms. Carell says that she hears projectiles being shot, or she doesn't know exactly what it was, but she said she hears tink, and particularly one loud tink. If you review that evidence of the evidence of the videos that are in evidence, you can actually see something hit the baseball bat of one of those people that is ducking. And it makes a loud tink noise, and there are more than one of them. There's a lot. There is, looking at that evidence, even in the light most favorable to the state, what you see is Alan Swinney is being shot at by something, and he pulls his gun. He says, "Hey, hey, hey," and when he says "hey," it stops, and then he puts his gun back in the holster.
State.
Your Honor, if the question is one of self-defense, if that's what I'm trying to follow the counsel's argument, it is certainly there's. I'm just trying to follow along. Certainly there is evidence, as I've stated before, about his saying even on that very day, he's there to fight. He is there to engage in this. Prior to that, there's tons of evidence that he was shooting a paintball gun repeatedly. There's ongoing evidence about that. It is one where it's a chaotic environment, but again, the state submits that he is the initial aggressor involved in this.
All right, I do, I agree that ultimately the jury is going to have to decide whether or not the firearm was pulled in self-defense, but I think that the state has enough evidence to survive motion for judgment of acquittal, and so count 8 will go to the jury. Count 9.
Same argument.
Same ruling. Count 10.
Same argument.
Same ruling. Count 11 and count 12. I mean, those are both kind of the same.
Sure. One additional argument with the pointing of the firearm.
Okay.
No, they had somebody probably even established him as an expert in terms of a firearm, and no evidence was offered as to what the range of that weapon was. A jury cannot make an inference from a void.
I think that a jury is allowed to use their common sense and knowledge when evaluating evidence, and that a firearms range is more than 3 feet. So I'm going to allow count 10 to proceed.
I mean, there's also nothing in the record to say how far away the crowd of people.
Well, there's video, and they're very close. So go ahead.
The people that are in front of Mr. Swinney holding the shield are not the people who's putting the firearm.
Okay. I understand. I think that the totality of the evidence shows that the people that were not that were holding the shields were not that far away from the people that the firearm was being pointed at.
Same arguments with the unlawful use of mace in the second degree as with the previous count. Same argument with assault in the fourth degree with regard to the intent aspect. And self-defense in both cases, I think.
Okay. And is the state making the same arguments?
Yes, sir.
Okay. So I think there is sufficient evidence in the light most favorable to the state for counts 11 and 12 to go to the jury. I think again, I know that I imagine the defense is going to be arguing identity. They're going to be arguing self-defense, but for all the reasons we've already stated, I think that the state has overcome, for the purposes of MJOA, the self-defense issue. All right, so that took a little longer than I wanted it to, and I told the jury to be back at 12:45. Is 35 minutes enough time for you guys to eat, or do you need a little bit more?
I'm fine.
That's fine.
All right, so we'll see you back here. And is it enough time for Mr. Swinney to get lunch?
Yeah.
Okay. All right, and then we'll shoot for 12:45. Probably shouldn't say that.
Before we shut off the stream for lunch, because I need to go get something to eat too, I do want to point out something that Judge Mo had said on Friday. She specifically was not paying attention to local news reporting over the last time period, and came into this case not really knowing anything, or not knowing much about the protests other than they were happening. So she is, and she said that part of that was so that she could evaluate evidence as neutrally as possible to help minimize her inherent bias. And she knows that those biases are there they instruct the court about that. That was actually part of the jury instructions that we saw Tuesday afternoon. So, yeah, at this point, the judge's job is more just to be an arbiter of the evidence and to make sure that the case proceeds smoothly. So that being said, I'm going to go ahead and shut down the stream here. Go ahead and get some lunch and stuff. I'll bring the stream back up in about a half hour. If you follow me on whatever social media you're watching this on, you'll be able to see when the stream goes live again. Also on our website, I will be updating with the most current links there as well. So, yeah. I would take a break, stretch your legs, get something to eat.